Good evening and welcome back this week to Balancing the Scales of Justice. Thank you for tuning in this week. I'm Shirley Millwood. I'm an attorney here in Calhoun County. My office is in Alexandria, Millwood Law Firm. I've been in the legal field 26 years, practicing law for 15 years. And I'm back this week again with Stacy Upton. And Stacy and I were talking last week about we started talking about bankruptcies, and as I told her, generally when a client comes in to consult with us, it's usually a minimum of 1 hour. We try to get it finished in 1 hour, so it was kind of hard to fit everything into a 30-minute segment. So you can go back last week, watch the rerun of last week's show, catch you up to where we are right now. We talked about Chapter 7s, Chapter 11s, and so I wanted for us to continue the conversation about bankruptcies to give you all some insight. And again, this is not case-specific information, but a general overview to give you some guidance and to help you navigate, getting started navigating the legal field, whether it's for you or someone that you know or love. Maybe this can help someone out there. And so Stacy Upton, she and I have been friends forever and riding together to law school and graduated law school together and worked together for years and years. And anyway, she is in Anniston. And Stacy, tell our viewers how to get in touch with you.
Yes, you can find me at uptonlawllc.com, or you can call my office. It's 256-770-8089, and that rings straight to me.
And what is your email address?
It is stacy@uptonlawllc.com.
And that's Stacy.
Yes, no E.
Yes. And this month will be Stacy's 15th year that she's been a licensed attorney as well. So between us, we have 30 years of licensed attorney experience sitting here together. Anyway, and I've been in the legal field 26 years, but how long have you been? Because you were in the legal field before you became a licensed attorney also.
I did. I started in 2000 working with attorneys.
So 24 years.
So 24 years. I started with an attorney here in town, worked a couple of months, moved to Chicago, worked in a law firm in Chicago, and then came back and worked at a law firm in Birmingham. And then from there went into law school and took your job at Young Wolstein with Tom Young.
Yes.
Working with him.
I was the first legal assistant that Tom Young had that worked for him for more than 1 year. And so all these years later, I still pride myself in that.
And I worked for him for 4, so I beat you.
You did. And now, though, his assistant he has now has been with him like 16 years. So
yeah.
she has beat all the records.
She's beat all of us.
But anyway, great guy, great law firm. I enjoyed my time there, and I learned so much and still learn from them, because I still don't hesitate to pick up the phone and call if I run in, have a roadblock and need some guidance in a situation. But tell us about a Chapter 13 bankruptcy. I hear a lot of people say debtor's court.
Yes, that's the old term for it.
And that is what we lawyers consider Chapter 13s, right?
That's what we consider a Chapter 13. Where last week when we talked about a Chapter 7, it being a liquidating bankruptcy, a Chapter 13 is a restructuring. You calculate a plan on how you are going to pay back the debts that you owe. So you take into account your income, how far behind you are on debts. You calculate a plan to pay the things back that you're behind, in addition to keeping the debts current. So it's tougher. It's a more difficult bankruptcy to go through, and they last a lot longer. They can last up to 72 months. They're long. Or 60 months.
I was going to say,
60 months.
60.
It's 60 months. Sometimes you can extend that under some
extenuating
circumstances. But it's like buying a car. You're in it for a very long time, and it's very difficult, and it's tough. So I congratulate my clients who make it through and get a discharge on a Chapter 13, because a lot of people don't make it through that process.
That is true. We've had some that, a good many that have been successful, but we've also had some who just couldn't. And, one thing that stands out to me is if someone's, just thinking, why would someone file a 13? instead of filing a 7. And the first thing I think of is if they're behind on their mortgage payments.
Absolutely. They're about to lose their home. They've gotten the letter in the mail. They're seeing that notice running in the newspaper where their home's about to be foreclosed on. That is triggering reason number 1 to file a Chapter 13, or at least why I would recommend them to file a 13, because in a Chapter 7 we talked about reaffirmation agreements and being able to keep the things like your home and stuff. What we didn't mention is you got to be current on those to keep them.
Yes.
And so if you're behind, that's where you get the plan to come in effect on a Chapter 13.
And so if someone comes in and they're behind on their mortgage, we take their mortgage arrearage.
Yes, you take that arrearage.
And I guess let's kind of summarize it real quick. So someone comes in to file a Chapter 13, they have to repay some or all of their creditors, right?
Yes.
But they do it over a period of 60 months, and then under some extenuating circumstances can be extended with approval of the court.
With approval of the court, and it's usually for that house, to keep paying that house and getting that, because they're behind on that house, and it's the house payment's large.
Okay.
And usually that's kind of where it comes
So,
or where I've seen it come through.
So basically, it's almost, I guess, kind of in layman terms, a debt consolidation, but it's not a debt consolidation.
No, it's you're paying those debts back, just in a different way than when you initially took the loans out, or the payments out, or the credit card payment statements. You're just paying it back in a different way.
And that just brought a good thought to mind. I know a lot of people hear a lot about debt consolidations, and correct me if I'm wrong, my opinion of that is if someone goes into a debt consolidation, that company that they're working with, they take all of your debts, they say, send everything to us, you're going to make a payment each month, we're going to deposit it into a trust account, we're going to negotiate with your creditors, and then as we get your creditor to accept X amount of dollars less than what you owe them, and you have enough money in this trust account, we'll take that money out of that trust account and we're going to pay that debt off, that negotiated amount.
Right.
But while they're doing that, your other, let's say you've got 10 credit cards, they're going to pay off one card. Those other 9 credit cards are hanging out there.
And they're not paying them.
And those are not yet being paid because there's not enough money there to pay those.
Correct.
So during that time, and I know as a bankruptcy lawyer back in the day, I saw this a lot. During that time, those other 9 credit cards are filing lawsuits and getting judgments against the...
Yes.
Yes, okay.
Yes, and that, I have not seen them as much as what they used to be really prevalent, but I have not seen them as much, or people using them as much. Again, I would recommend people not, but that is my opinion. That's not, I don't want to get in trouble with them and say that I'm bashing their business, but
no, because it can work well for some people, but
it can.
In my
opinion, if you're putting all your eggs in one basket and you're not distributing the eggs to the rest of the flock, only one person's getting fed, and that's not gonna bode well with the other creditors, because they're not going to care that you're making the deposits to this place. They're wanting their money, and rightfully so. They're going to go after their money.
And 2 concerns I have with that. One is that those credit cards that are waiting, or those debts that are waiting to be paid, because you've got to pay in that money. I mean, they've got to have that money from somewhere to pay those creditors, and that money's got to come from you.
Yes.
And so while you're paying that money in and they're waiting on you to get a sufficient amount of money paid, those other creditors are not getting paid. They file a lawsuit against you. My 2 concerns I have with it, one is they get a judgment against you.
And then after a judgment always comes the garnishment.
The garnishments, they garnish your bank account, they garnish your wages. I've seen them file writ of executions to come after your assets and ask that your assets be sold to collect.
Correct.
The other, and so then, what is it, 6-year statute of limitations on a collection account?
On a contract,
or
yes.
Contract account. So what about like a general, is a credit card a contract, or is it an open account?
It's depending on the type of credit card that you take out, but generally it's a 6-year. I look at it as a 6-year because you are making a contract to pay that each month. So,
excuse me. So what we're talking about, statute of limitations, is that creditor has up until, just assuming 6 years in a contract, 3 years for an open account, they have up to that amount of time from the date of last payment.
Last payment, not from when you took the credit card out. Last payment that you made.
And not the last time you charged on it either, but the last payment. They have that length of time to come in and file a lawsuit against you to obtain a judgment. When they obtain a judgment, that judgment is good for 10 years. Prior to the end of that 10 years can be revived for an additional 10 years. So now you've got a debt that was a 6-year statute of limitations that is now however long during that. Let's say they waited until 5 years and 10 months to file a lawsuit against you, and they get a judgment. They filed it within the statute of limitations. They get a judgment. Now it's extended for potentially another 20 years.
Yes, and then you get interest. Because once they get a judgment, there is interest on a judgment. You get judgment interest, and I think that's 6%.
I was thinking 7.65.
There's a 6 in it, but I couldn't remember off the top of my head what it is. But it adds up, and that interest will end up being way more than the actual debt itself.
Yes.
And then they put liens on your home and liens on your property.
And so when you go to sell your house, you've got to pay that lien before you can sell your house, right?
Or if you pass away, your kids are stuck with that lien.
And then the second concern I have with that is when you file a bankruptcy case, is it Section 362? The federal code section, which is
the automatic stay.
Yes.
It's 362.
And sorry, y'all, it's lawyers talk. So there is a federal code section. It's Code Section 362. That's an automatic stay. You have that federal law to protect you when you file a bankruptcy that prohibits creditors from coming after you and attempting to collect any debts against you while you're protected by that automatic stay. And then they have to file a motion for relief from stay
to keep collecting
and go through the whole course with the court and get permission from the judge to be able to continue collecting on that debt. You don't have that with the other avenue that we were discussing.
Correct. If you don't get that, and then even in a bankruptcy, if that has happened and you've got a judgment debt and they filed a judgment lien on your house, there's ways to get that lien removed in your bankruptcy, so that lien will come off your home as well.
And there's also extra steps to have to go through to make that happen, right?
There's extra steps, but it in the long run it's worth it because you get that off your home.
We're going to take a quick break, y'all. Come back and join us in a few minutes, and we'll continue this conversation talking about our Chapter 13s. Welcome back to Balancing the Scales of Justice, and Stacy and I were talking about the Chapter 13 bankruptcies, as a lot of people know as debtor's court. So let's, we were talking about the 362 automatic, the federal code section 362 automatic stay. How does that automatic stay protect a debtor? And when I say a debtor, that would be your client, the person petitioning to file a bankruptcy case. How does that federal code section protect them in a Chapter 13 bankruptcy, or really any bankruptcy case?
In any bankruptcy case, Title 11, 362, it goes into, it's an automatic stay, and I like to refer to it as kind of like the Harry Potter invisibility cloak. It covers you. Your creditors can't sue you. They can't garnish your wages. They can't call you. They can't mail you. They can't call and harass you 4 or 5 times a day.
Oh my gosh! I think that was one of the biggest things.
That was the biggest complaint that we hear, is that they call all the time, and it stops. And it doesn't happen like the moment I file, because they have to get notice of it. But after a couple of weeks of filing that bankruptcy, that should calm down for your client. Or for my clients, it does calm down usually. But if they keep continuing, there's other avenues that these creditors can get in trouble with if they keep calling and trying to take money out of your account. The adversary proceeding that I talked about earlier, which is our bankruptcy term for a lawsuit, you can turn around and file an adversary proceeding on them for violating that automatic stay.
And I did that before. I had a creditor who had continued to contact my client, and we had I ensured that creditor had received notice of that bankruptcy action, and they still continued with collection procedures even after they had been notified. So we ended up filing an AP. Attorneys call them AP for short, for adversary proceeding, which is akin to a civil lawsuit in the circuit court, but this is filed in the bankruptcy court. And we filed an adversary proceeding and was successful because they had clearly violated the automatic stay. And so those of you who are dealing with, you feel like you're drowning financially and you need some help, and you're looking for some help and some hope, call Stacy and schedule an appointment and go in to speak with her and let her help you assess your situation and give you some guidance and see if that's something that a bankruptcy is an option for you. But I'll tell you, if it is, just being able to file that and have those creditors to stop calling and harassing you is such a peace of mind.
And it is, because again, like I said before, the hardest thing you do is make the decision to pick up the phone to call. And by the time you have filed, you are ready to get them off of your back. And that is the last bit of getting them off your back, is to have that protection from the federal bankruptcy code to keep them from collecting on you.
And another thing, where we're talking about, saving your house, I've in the past, and I'm not sure if we can still do it, but in the past, I'd have people whose automobile was about to be repossessed, and we were able to file a Chapter 13 and stop that automobile from being repossessed.
Yes.
And so in a situation where you have a mortgage arrearage and you file a Chapter 13, you take that mortgage arrearage and I call it lump that into how much you're going to be repaying over the life of the plan.
Correct.
Okay. And then what about their monthly mortgage payment? What happens with that?
You still have to pay it. You still have to keep, if you want your home, you still have to keep paying. So you got to show to the court, not only can I pay my mortgage, I can pay a little bit to the back. And that's where the plan comes in, is to try to get an amount where you can pay the arrearage and the amount going forward so that it can get discharged.
Let me ask you, if somebody's facing foreclosure, to stop the foreclosure, if they obviously don't have the money to pay and they need to file a bankruptcy, when must they file to stop that foreclosure?
It has to be before that foreclosure takes place. There's a lot of things in bankruptcy court that is forgivable, but missing a foreclosure is one of those things in bankruptcy court that is absolutely not forgivable. So if they have the foreclosure and the foreclosure notice has already been filed with or the foreclosure deed, I should say, is already filed with the probate court, at that point in time, it's too late. It's already been foreclosed on, and that has already gone back to the bank. So you would need to see an attorney as soon as you get that letter saying, hey, we started foreclosure proceeding, and here's a copy of, they have to run it in the paper, so here's a copy of what's being ran in the paper. That's the time you need to go see your attorney, because you got to remember, your attorneys are sometimes in court, they're sometimes not in court, so you got to be able to make sure that they can fill out a bankruptcy petition for you in enough time to get it filed. So if you go see them, I'm not saying it's not possible that an attorney can't stop a foreclosure the night before, because it has happened, and I have done it.
We both have.
But it just makes things way more, it's just harder, because there's other things that has to take place. You've got to do credit counseling, you've got to get all of these documents together, and so if you're doing it at the very last moment, it just makes it difficult, but it's not unachievable. You can definitely do it, but it's just much easier if you can, as soon as you find out you're being foreclosed on, to make that call and get help at that point in time.
And if you wait till the last minute, you've got to find a lawyer who's willing to stay up past midnight to get it done and make sure that it can happen before the deadline.
After hours, yeah.
And I know we've done that a gazillion times before as well. So if the foreclosure sale is set tomorrow at 11 a.m., once you that clock strikes 11 a.m., you're pretty much done at that point. You are, as far as like done with being able to save your house,
Correct. You have,
or at least through a bankruptcy, should I say?
yes, through the bankruptcy. Yeah, it's
Because
it's
it
pretty
has
much
then
done.
began.
It has begun. It
Okay.
has begun, and it is time to turn back is going to be
And so,
almost impossible.
so if someone has an automobile that's being or being repossessed, I'm talking about foreclosure, being repossessed. If that automobile is on the back of that wrecker truck that the car lot or the creditor is sent out to pick up, you're pretty much done with saving that car as well, aren't you?
Pretty much.
Okay.
Pretty much. It, you know, it. Yeah.
But if you can, once you know you're behind and it becomes problematic and they're getting ready to repossess your car, like you said with the foreclosure notice, you need to get in touch with that attorney immediately if you want to keep that car.
Right, because most of the time, and most of your creditors, they're not going to come and repossess your car if you're 30 days past due.
Right.
We're talking several months past due, but don't let it get to that point before you talk to somebody. But you know you and you know your financial situation. Don't let it get to that last moment.
What if I have two cars and I'm making payments on both of them and I need to file bankruptcy because I'm in a financial situation, but I don't want to keep both of them. I only want to keep one. What can I do?
You can let one of them go if you want to.
So I can surrender one
You can surrender one and keep the other.
and reaffirm the other. Now, if I surrender it, am I still on the hook for that debt?
Depends on the type of bankruptcy you file.
Okay. And I guess also depends on whether or not you get a discharge.
Correct. So if you go through, let's say you file a Chapter 13 and you're not getting the discharge, which is the key word you want to hear. You want to hear discharge, not dismiss. Usually you want to hear that your case has been dismissed, not in bankruptcy.
No,
You want to hear
yes.
your case has been discharged. But if you go through that and you don't get the discharge, then that creditor can still come back at you for that debt.
So let's say we have a house with an arrearage on our mortgage. We're 3 months behind. We've got a car we're 2 months behind on. They're getting ready to repossess it. And, $20,000 in credit card fees and maybe a $15,000 unsecured loan. If I come in to sit down and I want to file a which obviously I'd have to file a Chapter 13
Correct.
to save that if that's the avenue I'm headed. And so we include that mortgage arrearage. We still have to be responsible for that monthly mortgage payment directly to the mortgage company, right?
Yes.
And then, so the car that I want to keep, do I pay the full amount of the balance owed or do I pay the value of that car?
It depends.
It depends. Honey, well, I don't know you're going to say that.
It depends. Most of the
Everything
time,
depends. I'm with a
Everything
lawyer.
depends. I mean, if you're getting one of the cars and unfortunately you get a extremely high interest rate, you can request that interest rate get crammed down
Okay.
through the bankruptcy.
Okay.
Just like getting a lien repossessed, there's extra steps you got to take, but it's not impossible. But you've got to show that it's a really high amount of an interest rate.
Okay, so we may be able to save some money by reducing the interest.
Correct.
Okay, and so,
Because you got to look at the value of the car as the value or what you owe on it. There's a lot of things that you got to take into consideration.
okay. And then we take all of the credit card debt, this loan, unsecured loan. Do those are the unsecured creditors, do those unsecured creditors always get paid in a Chapter 13?
They would like to.
Right?
They would like to, but not always. Sometimes they can get left out, and you propose a plan where none of the unsecured creditors get paid. But it's one of those it depends cases on kind of whether or not you got to look at what they owe versus what they have, and if they don't owe a whole lot of credit card debt and they don't owe a lot but they're behind, the court still may want them to pay that debt. So it's going to be a case by case situation where somebody's going to have to look at it.
And
in
also,
detail.
if they have excessive equity in their house, that
Absolutely.
excessive equity is going to be applied to unsecured creditors, right?
Correct.
Okay. So we can have debtors who have a 0% plan, a 100% plan, and those, when we're talking about 0% or 100% or 50%, whatever, we're talking about the amount that's being paid back to the creditors,
Yes.
unsecured creditors.
Yes.
All right, so let's say the lawyer formulates and the court formulates a plan for an amount that we have to pay monthly, the debtor pays monthly. That also can be withheld from their pay.
It can be withheld.
Which is nice for a lot of
Which
people.
is nice. So you would ask the trustee to withhold that from their checking account, and then she sends not a garnishment, but a withholding form to your employer for them to withhold that amount and to send that directly to her. So it's coming out of your paycheck, going straight to her, so you don't have to worry about making that payment. She's going to get that payment, or he's going to get that, depending on which trustee you have, depending on where you file.
And that makes life a lot easier for a lot of us. The other thing is, so let's say you tell me what amount I have to pay. I pay that amount for 5 years, 72 months, whatever it may be. At the end of that, I have completed all those payments. Then I get a discharge.
Yes.
None of those creditors can come back to collect from me
Cannot
again.
come back.
But let's say I get 3 years into this plan and I stop making payments and it gets dismissed. It's almost as if I never filed, right?
It is exactly if you've never filed.
Okay.
They can
Stacy,
come right back at you.
Thank you so much, y'all. We're about to be done. I'm sorry, y'all. This time just flies so fast. Thank you so much for being here and sharing your knowledge with us and with the viewers. And I hope that we were able to help you all. Thank you for tuning in, and I hope you will join us again next week, and we'll bring some more legal knowledge to you.